speaking on the phone, and all you could see was the two black guys who were just sitting there, like looking at him. It was really quite radical. They did it 4 times and at the end.
Good evening, everybody. Thank you so much for joining us this evening. I'm Rebel Clinton. I'm the Law Reform Assistant with the Environmental Defenders Office Queensland. And I'm so happy that so many of you have chosen to spend your evening with us to discuss the human rights to a healthy environment that we believe you should have, and clearly everybody in this room has an interest in. Nearly 700 people showed interest in this event on social media. Maybe 700 people haven't turned up tonight, but I think it's a clear example of how much interest there is in this right being reflected as a human right in our new Human Rights Bill, and hopefully nationally one day. But before commencing our event, I will first recognise that we are on the land of the Turrbal and Jabberwock people, that they did not seek this land, and that the First Nations people of this country are still suffering at the hands of significant racism, injustice and human rights atrocities on all fronts to this day. And I pay my respects to the elders past, present and emerging of the First Nations people of this land, and acknowledge that they have known for over 60,000 years how to live in harmony with this land, ensuring all beings have a healthy environment, and that this right was taken away from First Nations people upon European settlement. I will warn people, this event is being recorded, but only the first segment. So when we get to question and answer, that part will be recorded. And we might leave it questions and input till the end of question and answer. But tonight, so we're here to discuss whether we all deserve recognition of our human right to a healthy environment. And this is in the context, obviously, of a human rights bill being before the Queensland Parliament right now. And what a momentous time in Queensland that our human rights might actually be reflected in law. It's a long time coming. And we're lucky enough to be joined this evening by Amy McVie, who has been coordinating the campaign for a Human Rights Act for Queensland, and who can be thanked as one of the key people who helped get this bill into Parliament this term of government. Amy has made a big contribution to community wellbeing across multiple areas of law, both internationally and in Australia. And she's worked with NAMRI to establish Disability Law Queensland, which focuses on assisting people with a disability and their families plan for the future. She's worked for Pave the Way, helping Queensland families to understand the legal aspects of safeguarding a good life for people with disability. Amy's had extensive experience working in areas of discrimination, succession planning, administrative law, child protection and human rights, including working as an advisor to the UN Special Rapporteur on the rights of Indigenous people with a focus on gender perspectives. And in 2017, I understand Amy was awarded Australian of the Year State Finalist for her impressive work promoting the human rights of vulnerable people. So it's a real honour to have Amy here to provide an overview of the new Queensland Human Rights Bill. And I won't steal Amy's thunder, but by way of synopsis, this new bill is a great achievement for a state in many ways. It recognises legally 23 human rights, more than actually other states in Australia in the equivalent human rights charters and bills they've enshrined, provides mechanisms to ensure public sector functions and decisions consider and are compatible with human rights. It provides for a human rights commission that we can take dispute resolution requests for dealing with human rights complaints to. While it doesn't provide a standalone legal right to have a breach of human rights dealt with, it does allow for the power to piggyback a claim of unlawful contravention of the Act onto another independent cause of action, such as judicial review. But it also provides a means of embedding the idea and concept of human rights into our culture more, both through public sector and the broader society, so that this is actually on the agenda for us when we're making laws or discussing policies that are proposed. And that's pretty significant. But one thing this bill is obviously missing is recognition of a right to a healthy environment. To put the need for this right to be protected most bluntly, if we don't have clean air to breathe, if we don't have clean water to drink every day, we don't exist for very long as a species. But also if our climate collapses and we're struck by increasingly fierce and lethal extreme weather events such as larger cyclones, longer droughts, bigger bushfires, like the horrible bushfires we've seen in Queensland just recently, and sea level rise swallowing up our coastlines. These circumstances leave little room to think about other human rights. But also, what if the land we live on and make our livelihood from is taken over by, say, a resource company, and the groundwater basin we've depended on for our livelihood is suddenly contaminated, or no longer is able to provide water for us to keep going with our livelihood and our existence out there? Is this not an important question for our human rights? So this is not just a hypothetical question for many people across Australia and in Queensland. And we're honoured today to be joined by Shay Dougal, who's generous enough to provide her insights into having to deal with just this issue. Shay is a force to be reckoned with. She has 20 years experience as a health and safety professional across waste energy, wind energy and unconventional gas. She's currently studying a master's in occupational health and safety. She's a wife and mother of two, and but she also lives in Queensland Western Downs and amidst gas fields. Her family has been impacted by the leak energy contamination, and they were faced with the expansion of Origin's gas fields into Oakland. And so for the past 6 years, Shay has dedicated herself to advocating on behalf of her family and over 30 other families that have been affected by unconventional gas. And I really take my hat off to Shay for the immense work she's done to represent the interests of people out there that are so often forgotten in our legal framework. So this has included an enormous variety of impressive feats during that 6 years, but most recently Shay has convened the Australian chapter of the Permanent Peoples Tribunal session on human rights, fracking and climate change. So this is the PPT is known, it's an internationally recognised human rights, civil rights tribunal. It's independent from any state authorities and instead provides a forum to hear from those members of society whose voices aren't often heard within our legal frameworks globally, and applies internationally recognised human rights laws to whatever impacts our societies, our cultures and marginalised people are experiencing, to actually get evidence on the public record from these communities that are so often silenced. They're incredible processes. Michelle Maloney, our other speaker this evening, has convened a similar one on the Great Barrier Reef a few years ago, not of an international Permanent Peoples Tribunal, but a similar process which was incredibly powerful as well. And I was honoured to be the co-lead attorney with Dr. Evan Hammond from QUT this year for the PPT around fracking, climate change and the human rights impacts. And I can attest the immense gravity and importance of these forums. So Shay will be discussing the outcomes and recommendations of the International Permanent Peoples Tribunal, to which our third speaker, Dr. Michelle Maloney, was also a witness this year. So Michelle is a co-founder and national convener of the Australian Earth Laws Alliance. She is also co-founder of and on the steering group of the New Economy Network Australia and adjunct senior fellow of the Law Futures Centre at Griffith University. Michelle is one of the leaders of earth jurisprudence and wild laws, both in Australia and internationally. She's an absolute legend in this area. She has more than 25 years experience designing and managing climate change, sustainability and environmental justice projects in Australia, the United Kingdom, Indonesia and the USA, including 10 years working with Indigenous colleagues in central Queensland on a wide variety of community development projects, sustainability and cultural heritage projects. So we're very blessed to have Michelle joining us tonight to share her reflections on international recognition of the right to a healthy environment and the intersection with the rights of nature. And I'll be your MC tonight. As I said, I'm with the EDO Queensland. We're a community legal centre based just down the road, but there is one in most states in Australia. And we provide free legal assistance on any matter that's of public interest to do with environmental impacts to both community health, but also obviously to our environment. So we provide legal advice, educational service, law reform, which is my area, and legal representation, all with a view to trying to empower people to have more of a say in the decisions that affect our communities and our environment, because it's the people like you who are the ones standing up and holding our decision makers to account. So we need to make sure that our decision makers, that our laws, actually provide meaningful opportunities for you to do that. So we're also keen advocates for this need for a right to a healthy environment to be reflected in our law. Nationally would be ideal, but since we have a human rights bill before Parliament, it's a perfect opportunity for us all to raise this issue with our government decision makers and show them the need for this law to be protected, this right to be protected. And this is not a new idea. Many countries and subnational groups, subnations, regional areas have actually reflected human rights, the right to a healthy environment in their laws. Michelle's going to be giving you a wonderful overview of the international reflections of the right to a healthy environment. But in fact, any constitutional bill of rights that's introduced now is actually at odds with widespread global practice if it doesn't include a right to a healthy environment in it. So it's not actually out of place, even though it might seem so if we haven't heard about this so much in Australia. Australia is one of only approximately 15 other countries that doesn't recognise a right to a healthy environment. And what does this actually do? The reflection of a right to a healthy environment has been found across Latin America, Europe and Asia to have enormous benefits to the protection of their environment and to community wellbeing. It's been found to strengthen existing environmental protection laws and policies and encourage the introduction of new, stronger laws. And it has also helped to prevent governments from rolling back effective laws between policy changes and political party changes of policy. So they have been enormously beneficial. Consequently, these nations have smaller ecological footprints, they've succeeded in reducing pollution faster, and they rank higher on international indices of environmental performance. So wouldn't it be wonderful if Australia, or at least if Queensland, could also benefit from these wonderful outcomes by recognising a right to a healthy environment? I might just add, Australia does have at a national level since 2011 a parliamentary joint committee on human rights, which examines the compatibility of proposed legislation against many human rights that are recognised internationally. And yet this doesn't actually include recognition or consideration of a right to a healthy environment. And this actually came out in 2016 when you might remember there was an attack on the standing of environmental protection groups under our federal environment laws, the Environment Protection and Biodiversity Conservation Act, whereby the standing that's actually guaranteed in this act was put in question. And at the time, the Federal Minister for Environment stated that there was no standalone right to a healthy environment, and thus the committee could only consider legislation's impact on environmental protection indirectly, for instance, the right to a healthy, right to health personally, and not to the overall right to a healthy environment. But without further ado, I will invite Amy McBee to the stand to provide a synopsis of the human rights bill that's before Parliament, so we can get into context what we are actually facing in Queensland. So please join me in welcoming Amy.
environmental law expert, but I'm so keen to talk to you tonight about the Human Rights Act, the bill that's currently before Parliament, and then be engaged in a conversation that I am very interested in about how this Human Rights Act might help to protect our right to a healthy environment, and how what opportunities there might be for improving the bill. Just I guess from a personal perspective, I've been campaigning for this Human Rights Act for about 4 years now. I've been doing it in addition to my paid job, and also I've got 2 tiny children, one of which is born during the campaign. And so it really is particular meeting really put the fire in my belly because we were talking about, we need a Human Rights Act, and he said two things to us. He said, we don't have any human rights issues in Queensland. And he said, even if we do, we have adequate human rights protections already in place. And I said, well, can you please explain to me what those human rights protections are? And he said, it's like this. So we make a political decision about whether to limit your rights, and you tell us whether you can stomach it. They were the words that he used, through the ballot box. Now that got me going. Because, we're more than the ballot box, we're more than our vote, and our campaign is actually a testament to what can be achieved when civil society does work together, because our campaign, if the Human Rights Bill's passed, I'm sure there'll be lots of commentary on how Queensland achieved a Human Rights Act, but my personal view is that civil society played an absolutely essential role in ensuring that our rights are properly protected in law. So I thought what I would talk about tonight is just really what a Human Rights Act is, and then maybe a little bit about how it all happened. So in terms of a Human Rights Act, a lot of people describe it as a dialogue model, what we're talking about. So really focusing on three arms of government. So each arm of government has a role under the Human Rights Act. And so, for example, when new laws are written by legislators, they will now have, if the bill's passed, they will now have an obligation to consider how that new law, shivers, sorry.
You can hold it if you want to walk around, just hold it.
Okay, yes, I'm a bit of a walker, so. The legislators will have to consider whether the new law interacts with our human rights, and if it does limit our rights, whether that can be properly justified. When the courts are interpreting laws, they have to do it in a way that's consistent with the human rights in the Act. So not in a way that deviates from the legislator's intent, but where possible interpreting the law in a rights-consistent way. Probably the thing that we've been most focused on is the obligation on public entities. So that's government departments, but also non-government agencies and companies that are delivering services of a public nature. So, a perfect example would be if you've got a prison and you've got a private company providing security within the prison, they would still be caught by the legislation. So the public entities then have an obligation to consider the human rights in their actions and in their decisions. So that's the role of the different arms of government. But I think it's also really important to think about what's the role of people in a Human Rights Act, because it's a Human Rights Act after all. And we've always been very focused on that role. What's our role going to be on making sure that governments are accountable when they don't protect our human rights? And so for the campaign, that's about enforceability. How do we enforce our Human Rights Act? And really how we would define enforceability is that where you feel that your human rights have been unjustifiably limited, you should have a place that you can go to complain. So, for example, similar to our anti-discrimination legislation, where you can go to Anti-Discrimination Commission, where it would say you should be able to bring a human rights complaint to Queensland's Human Rights Commission, and then that complaint should be able to be conciliated, and outcomes of those complaints should be made publicly available so that we as civil society can monitor what's happening through the commission process. We would then say that individuals should be able to make an application to a court or a tribunal where their complaint hasn't been resolved through the conciliation process. And then that court or tribunal should be able to order an effective remedy, including damages. So then we need to look at how does this bill, the Human Rights Bill 2018, stack up against our kind of understanding of what an enforceable act is. And for those of you that have read the bill or followed some of the commentary, you know that it ticks some of the boxes. So unlike any other jurisdiction in Human Rights Commission will be able to conciliate complaints and then may publish reports. So it isn't mandated to publish the outcomes of complaints. It will come down to what what type of commissioner we have at the time. So that's really good. The Commission's got some really broad investigative powers, able to compel public authorities to produce information, able to initiate their own reviews of different public authorities. So say they're identifying a systemic issue, say you've got a whole bunch of complaints about the police that are of a similar nature, the Commission could then decide itself that it was going to do an investigation in relation to that issue and compel the police to produce the documents that they need. So it's really quite an exciting and powerful feature of the bill, the powers that the Commission has and that complaints mechanism. And as I said, it's a first for Australia. Unfortunately, the Queensland Government have taken the decision to model your ability to take an action to court on the Victorian Charter of Rights and Responsibilities. So in the Charter and in our Human Rights Bill, you won't be able to take your action to a court or a tribunal unless you've got existing legal proceedings. So you've got this strange, clunky, kind of complicated way of access to justice. So, for example, if you're a woman involved in child protection proceedings and responding to child protection proceedings where a child's being removed, you'd be able to raise your right to family and your right to non-discrimination before the law within those proceedings. But if you were dealing with child protection just on a day-to-day basis and you felt that your right to family wasn't properly protected, you wouldn't be able to initiate proceedings just on the ground of that breach. It's really disappointing to see that because the Victorian Charter was recently reviewed. It was an independent review by Brett Young, and the review found that piggyback provision, where you have to attach your human rights claim to an existing claim, was just unnecessarily complex and clunky and was leading to people not making their human rights claims. And he recommended that the Charter be amended so that, like in the ACT, in their Human Rights Act, you can actually make an application to the Supreme Court just on the basis of a breach of your human rights. You can imagine the fear and the hysteria is, this is a lawyer's picnic and we're going to open the floodgates to litigation and here we go, the lawyers are going to be flying in from everywhere to run these human rights cases. That's just not borne out in any jurisdiction that has human rights legislation. Any lawyer that does discrimination work will tell you that there's no money in discrimination. There's no money in this area of law. That's really not what it's about. The interesting thing, I guess, the difference between what we were hoping for and what exists in the ACT is that we thought maybe rather than an application to the Supreme Court, you could have an application to like our Queensland Civil and Administrative Tribunal, so that where people can't afford an application to the Supreme Court is a pretty expensive thing to do, whereas people are able to access QCAT even without a lawyer. So unfortunately, that's off the table at this stage. The bill requires you to piggyback your claim onto an existing claim, and also even if you are successful, the court can't order damages. So they can order a remedy, and I think it's always important not to overstate the importance of damages, because in the work that I do, most clients are not interested in damages. What they're interested in is fixing the problem. So really practical outcomes that you see for individuals through human rights laws, case examples from Victoria, for example. One that I think is really powerful, a woman with a disability living in shared accommodation was being showered in front of everyone, in front of all the other people and in the accommodation. And she used her right to privacy under the Charter to ask for a shower curtain. So in that case, it's not an application damages are really important because sometimes all that can be done is that you can be compensated financially, but it's not the only thing we're after. Usually what we're after is a change in behaviour or a new decision that's human rights compliant. Our Human Rights Bill contains 23 human rights. Most of them are civil and political rights drawn from the International Covenant on Civil and Political Rights. And then we've got two economic social rights, which is the right to education and the right to health. The right to health is not protected anywhere else in Australia in human rights legislation, so that's another big win. And also a really exciting feature of the Human Rights Act is the protection of the cultural rights of Aboriginal people, which is really exciting to see. In terms of a right to a healthy environment, as you know, that's not protected in this bill, but rights that might be relevant are things like a right to life, a right to health, even freedom of expression and freedom of association are relevant to work connected with work connected with seeking a right to a healthy environment. And often what happens with human rights, as many of you would know, is that a lot ends up being read into an overarching right, like the right to life. As Rebel was saying, so much of a right to a healthy environment is related to a right to life. I just wanted to make a few comments about our campaign and where it's come from, just to kind of illustrate that this really is a civil society movement and how it's all kind of come to pass. So it all started because, well, firstly I should acknowledge that, people have been campaigning and lobbying for proper human rights protections in Queensland for a very long time. This campaign is certainly not the beginning of that work, but back when we had Campbell Newman as our Premier, you would remember that there was some pretty scary human rights issues going on. And at that time, Peter Wellington, the independent member for Nicklin, was sort of saying, hey, this is crazy. We're having laws passed by this Parliament in the middle of the night that are seriously limiting our rights to things like freedom of association, freedom of movement. And we don't have anything in Queensland that stops this or even slows this down or even tells Queenslanders what's happening. And he said if we had a Human Rights Act in place, at least the government would be required to properly justify limiting our rights. So he was saying we need a Human Rights Act. But I don't think anyone expected that very soon after that we would have a change in government. And what was, even more poetic, I guess, in terms of our human rights protections is that Peter Wellington had to support the Labor government to form a minority government. And in the letters of exchange between Peter Wellington and the Labor government, there was a tiny little commitment to looking at the issue of human rights and publishing a report. And it was off that little seed of hope, I guess, that lots of community organisations and lots of people in Queensland got together to build a campaign which has ultimately led to this bill. And so I guess it's a little bit of hope to show what is possible when people work together, and hopefully, tonight will be another opportunity for more ideas about how we can better protect human rights in Queensland. Oh, and if you want to follow the campaign, please get on our website and sign up for updates, and obviously we're also on social media. Thank you.
Fantastic snapshot of the bill before Parliament, and congratulations and thank you again for your work. bill before Parliament that we're dealing with. I'd now like to welcome Shay Dougal to the stand to provide an overview of what the reality of Queensland looks like without right to a healthy environment actually protected under our laws, and a snapshot of the Permanent Peoples Tribunal. So please take away Shay. I'll take your slides up. There will indeed, right at the end, yeah. With enough time for plenty of discussion.
Don't forget if you walk off, hang on.
Thank you everyone. Thank you for coming out tonight. I really appreciate it. This is a really exciting opportunity. And I want to thank also all of the hard work from Amy McVeigh and all of the people that have led to this point in time where Queensland looks like it might just get a Human Rights Act, which is ironic given what the Queensland Government is trying to do to the area that I live in. So I am happy to join with you today and share my experiences. Sorry, I think I might just hold this, it might be better. Okay, so my name's Shay Dougal. I'm a wife and a mother, and I'm a landholder advocate. I live in Chinchilla, and I'm an OHSE professional. I'm currently studying my Masters. I'm just 12 weeks out from finishing it, and my coincidental final report that I'm writing to achieve my Masters is about the OHSE impact of this unconventional gas industry on the host landholders who are expected to live with the industry. So, can you all hear me okay?
Yeah.
Okay, so for many people, the issues of human rights and their defence and their violation may be thankfully something that's just a philosophical consideration in this day and age and in this country. Unfortunately, for some people, it's not. It's a shockingly basic but profoundly powerful aspect of their day-to-day existence that is incomplete, that is raw, that is exposed, and that it eats at their fundamental enjoyment and fulfillment as people. And it's my experience that that is actually happening just 3 hours west of here. So the screen's just gone off, so I've lost my cues. So what I'm talking about here is unconventional extraction. How many people here have heard about unconventional gas? Great. So that's what we're here to talk about today. And this picture here is what I'm talking about. What we've got here is a picture of where I'm from, Chinchilla, and the township of Miles and the township of Dalby. And between those three towns, what you can see there is over 22 major pieces of infrastructure. There's gas processing plants. Within 100 and a bit kilometres, red shading across the whole community there is land that is now owned by the multinational gas companies. They used to be owned by mums and dads, but now that land is owned by multinational gas companies. So it makes a huge impact on that community. Another version of that same picture, those red crosses you can see are what you were seeing on that previous slide, which is the major infrastructure. But this is now also including all of the wells. So all of the gas wells that are across that community are the yellow triangles that you can see. What you can't see in that picture is all of the other infrastructure that goes with each of one of those wells. So each one of those wells is about a hectare in size. Each one of those wells have high point vents, low point drains, and chemicals brought in, roads, and all sorts of other infrastructure that you can't see on this map. Coincidentally, those black circles you can see there are actually stock and domestic water bores that are no longer going to be available for the farmer as a direct result of this industry. But from the landholder perspective, from the person who's expected to host this industry in their backyard, I thought I'd give you my version of what that actually means. So this is my picture of a farm and his neighbours. Along comes the gas company and says that you're required to sign this contract to give us access to your property. They come along and that contract only contains a handful of very small compensatable effects, and that's about it. They come along with a whole bunch of people, a whole bunch of equipment, and install roads and a whole lot of construction on your property. Then they drill and they drill and they drill and they drill their wells. Then they install a whole bunch of pipelines underneath the ground that you don't exactly know where they are. They install high-point vents, the little manholes all over the place, low-point drains, and of course all of this involves importing chemicals onto your property. Then they install temporary water ponds and communication towers. I think there's about 22 communication towers in that map I showed you earlier. They then install their own electrical infrastructure and high tensile power and their own power generation. They then install all of their major infrastructure that I showed you over 22 of in that small part of our community out there between Miles and Chinchilla. So I have advocated for approximately 30 other families who've had that lived experience. What I also didn't mention was those houses, those neighbours disappeared as well off that previous picture. So, and I've also advocated on my own family's behalf. I had first-hand experience of the impacts of this industry, what it has on individuals, on families. I've had first-hand experience at trying to approach the government on behalf of those families in this community and trying to explain to them what was wrong, what we needed help with, how we needed it resolved. And I've had first-hand experience of being blocked at every turn. So when we're talking about Human Rights Act in Queensland, what we're talking about is trying to find the language to defend ourselves when things like this happen. It was through the advocacy of the Sisters of Mercy who came out to Chinchilla about 3 years ago to advocate on our behalf because of the extreme extraction that was happening in our community, that I found out about this thing called the Permanent Peoples Tribunal that was going to be held. And as Revel explained earlier, the Permanent Peoples Tribunal is a way in which it's a civil society group of people who are external to other countries, so they're outside of the state. They exist independently of the state. So they apply internationally recognised human rights law to the problems that are brought to them, and they provide their weight behind the issues you bring to them. So them addressing this issue of fracking and climate change was really important because until then we hadn't been heard. So they gave us a place to be heard. So the session of the Permanent Peoples Tribunal that was held earlier this year was actually the first one that was held virtually. So it's available for you to look at. And I beg of you to go and look at it. It was an extraordinary thing to be involved in, and an even more amazing thing to watch, to see it unfold. And all you need to do is Google the Spring Creek Project YouTube channel, Permanent Peoples Tribunal playlist, and you'll get the entire tribunal, the entire week's worth of evidence, presentations, oral presentations, and people's witness statements, which was an extraordinary thing to watch. So we in Australia also collated our own evidence to provide to this Permanent Peoples Tribunal, and their website where we hosted our evidence is that website there. And the reason we wanted to host it on a website is because we thought it would act as something in perpetuity, that it would continue to be built on, that it would continue to be a witness of what was being experienced in our community. So the structure of our of what we put together for the tribunal was based on asking the tribunal, which existed of 10 other international judges, and we had an Australian lecturer also who attended as a representative judge, and we asked them to give an opinion on our evidence that we provided them. We split that up into 5 subcases to make it a little bit easier to present our evidence, and those 5 subcases were health, infrastructure, climate environment, government participation, and social and cultural. We then provided a final summative report that we based on the 16 framework principles that John Knox, the Special Rapporteur for Human Rights and the Environment, produced as his final report. That particular report is an amazingly simple, easy to read and clear example of what it is that needs to change in our country's governance and the way in which it deals with people and the interaction with their decisions and the environment that we're expected to live in and hope to survive into the future. So we wrote our report based on that report of the 16 framework principles and identified how our evidence showed that there were gaps in our country's governance. The evidence that we provided was firstly on the health section. We showed that the health is not considered in any point, way, shape or form in our government's energy policy. That air, land, water and noise contamination that is addressed under Environmental Protection Act and is addressed in a very arbitrary nature. It in no way reflects any health implications. We also showed that in undertaking this industry there was no baseline testing done. There was no requirement to do any baseline testing, and still to this day, 10 or 12 years later, there's been no health impact assessment of what this industry does to the community expected to host the industry. So that's the type of evidence we were able to provide based on the health implications. We talked about the infrastructure and the impact it has on our human rights. We showed in our evidence the scale and the intensity of this industry, that it is totally unprecedented, that it's something that is inconceivable unless you see it firsthand, the invasiveness of this industry, that it's literally in the backyard of families. The infrastructure has massive implications for property values, noise, light, dust, and leaks, and the way in which those things are handled. The way in which our government manages those issues has been to date to remove the rights that might have already existed. And in fact, the good example of that most recently is the Mineral Waters and Other legislation bill that was passed that specifically had the rights of neighbours of this industry not able to apply for any compensation or acknowledgement of any impacts. They've changed that legislation now so only people with this infrastructure on their property can claim compensation effects, and that's only just the handful of compensatable effects that the PNG Act allows for. So neighbours are now not included, and I can guarantee you that the impacts from this industry do not respect any fence boundaries from the neighbour. And also the industry infrastructure not only means that it's impacting people just by its existence, but it's actually requiring the removal of agricultural infrastructure. So while this industry expands, the farmers and the agricultural industry lose access to their water. The climate and environment evidence that we provided to the PPT included that the government we showed how the government actually allows the primacy of this industry over the industry of agriculture, and we showed that fails to consider our basic future needs. We showed the cumulative impacts of this industry not considered in any way. So with the permitting and authorisation the government gives to this industry, it's done on a project by project basis, and there's not even any consistency between the permitting that's allowed for one company to the next or one project to the next. And it just has no capacity to understand the cumulative impact of one project after another. We also showed that methane, in our evidence we proved that methane, which is a very powerful greenhouse gas is completely inappropriately regulated, monitored and reported on by this industry. And the impact of the fugitive emissions on our community is extensive. We also showed in the way in which we lack our participation in our government, in the evidence we provided, we showed that the government has been deliberate and relentless in its pursuit and creation of this industry. We showed that the government has gone out of its way to remove red and green tape, and in a way that supports the industry, instead of, as Amy said earlier, considering the impact that would have on the public and the community expected to live with the industry. We showed that the way in which they pursue this industry means that they've avoided investing in alternative energy. This has all resulted in really serious impacts on people's human rights, like there's people that live out there don't have the right to veto the industry coming onto their property. There's rampant industry lobbying and political door swinging that goes on. There's a failure in compensation arrangements. The compensation arrangements are limited to a handful of compensatable effects that no way represents the actual real impacts that people experience from the industry, which leads on to the fact that there is very little information provided. So when people are expected to sign a contract, the information that they should have to have a really informed consent to sign permission for these people to come on doesn't exist. There's also opens the door to extremely unconscionable conduct by the industry. There's a failure to investigate incidents and the impacts of this industry. Failure to prepare for industry-related emergencies. An example of that is at the moment the bushfires that we're experiencing in Queensland. There was 3 fires out in my way where I live, and they were reported on in the local community newspaper as there's a local bushfire, but not at any point was it mentioned that it's in the middle of the gas field. And this is the first time we've had a bushfire in that area, when 10 years ago, the last time we had a bushfire there, many people lost their homes. And that was before the gas industry was established in that area. So there's a real disconnect between what actual impact that will have on the risks that people actually face living within that gas field. There's also, all of this leads to the basic point that ultimately for you to be able to prove any impact, or for you to be able to approach the government to provide any justice for the impact that you've suffered from the industry, you are required to produce that proof yourself. There is no other external form of information or support. It's up to me, you, your neighbour, to pursue and fight a multinational company that has very deep pockets and a bunch of QCs on their speed dial. So, that was the evidence we provided to the PPT on government participation. And finally, the social and cultural impacts of this industry. The evidence we provided to the PPT showed that traditional owners are consistently unrepresented and under-acknowledged in the approvals process. That Australian Pacific Islanders are going to be the first people who suffer from these impacts that come from the emissions, the rampant emissions that this industry is allowed to continue to get away with because it's not measured or acknowledged in any way. This industry actually has access to our curriculum, and the industry has been forced onto the people in the community, which causes impacts within families, it causes impacts on their recreation, it causes impacts on their businesses, and unrelenting stress that tears at the community and it tears apart. So, well, what happened then was the PPT outcome so far is that they have issued a preliminary statement. But in that preliminary statement, the outcome is validation. So basically what the experience that we had from partaking in the PPT is exactly the purpose of the PPT. It made us feel validated and heard and gave us a platform to provide the evidence that we did. The final statement from the PPT, the final advisory opinion that we've asked for, is still coming. So we're very excited and waiting, and it's imminent. In fact, we were hoping it would be there today already, but it's still on its way. So any minute now, we'll be hearing about the final advisory opinion. But the preliminary statement in itself was validation. And interestingly enough, out of the 17 Commonwealth and state inquiries that have been held into this industry, the same evidence that we provided to all of those inquiries, that was pretty much the same evidence we provided to the PPT. So what fell on deaf ears in our government ended up with the following outcome from the PPT in their preliminary statement. So their preliminary statement said that the evidence that we provided them clearly demonstrated that this industry had failed to fulfil its legal and moral obligations, that the government have failed to regulate the industry so that it protects people, community and nature. So that's validation, they're right there. They went on to say in their preliminary statement that unconventional gas is ongoing and it's expanding and it affects the rights of nature and the rights of individuals. And it has specific and dramatic consequences for the Indigenous population. They said that the practice that the government and the industry have of devaluing our rights that we already have, most of the time is planned by the government and industry to devaluate our rights. And that it's done intentionally. And that when we call them out on it, they deny or hide the fact that they did it that way. Their preliminary statement went on to say that they don't see the existence of this big black hole as a problem. They see it as an opportunity to go ahead with impunity. In their preliminary statement, they went on to say that this industry is an exemplary model of a tragic hierarchy of values, that it's a sort of systematic crime architecture. And that's their preliminary statement. So, you know, the fact that this is what the PPT does is magnificent. So it's given us complete validation that the concerns we had that our government refused to listen to have been heard, and this preliminary statement says everything that we've been trying to tell our government. So basically the unconventional gas industry exists because of the failure of our government to consider human rights and because we don't have an instrument to defend ourselves with. So in this boxing ring, which is the field of conflict between us, the industry, and the community and the government, what's missing from that boxing ring, the reason why we're never able to get anywhere with our complaints and demands and requirements for justice, is that these things are missing. Our right to information, our right to informed consent, our right to health, to participate in our government, privacy, land, culture, water, healthy and safe, sustainable environment. Those things don't exist in our government at the moment. They're not required to consider them when they make decisions. And we need them to. So the evidence that we provided in the preliminary statement from the PPT is a practical demonstration of this Human Rights Act and what it should contain. Because ultimately, the human rights and environmental protection are interdependent. You cannot have human rights without having a safe and sustainable environment. So what's next? Well, stay tuned, like I said, for the release of the final advisory opinion from the PPT, which will be an amazing outcome. And what we'll need is people to be, for people to hear that final outcome and to support it and pursue it and spread the word. So we also want people to spread this concept that human rights are missing from the field of conflict and to include this aspect of human rights into any type of action or campaign that you're undertaking, any letter writing you do. Include it in when you go to vote next. Make it one of the basic things that makes you decide who it is that you think should be making these decisions. And as Amy suggested earlier, the Human Rights Act provides some new language that we can use in order to identify the things that are wrong and to seek out justice. And along those same lines of the new language that we can use is these 16 framework principles of John Knox. So in those 16 framework principles, it's very eloquently and simply put things that we should be asking our government to make sure they're doing whenever they make a decision, particularly about this particular industry. So thank you for your time this evening.
Thank you so much, Shay. Please join me again in lucky to have such an incredible advocate who can articulate so well the impact those industries are having out in our regional communities. So once again, I take my hat off to the work you're doing.
Thank you so much.
Thank you. I now welcome to the podium Dr. Michelle Maloney from the Australian Earth Laws Alliance. I am sorry.
I'll do it.
Do you mind?
I think you've lost it.
I have lost it. How do we do it to the desktop?
It's right. Now I've lost the mouse.
So, Michelle will be giving an overview of the international reflection of the rights to a healthy environment and also how they intersect with the rights of nature.
Yes.
Thanks so
Thank
much,
you.
Michelle.
Good evening, everyone, and I'll be relatively quick because for me this evening is really about acknowledging the amazing work that Amy and everybody has done to get the bill to the government, which I think is a huge. I honestly never thought I would see the day in Queensland when that would get to where it is. So well done, absolutely huge. And I'm already a huge fan of Shay's work, and Ayla has supported Shay wherever we can in trying to get the stories out because. For most people, we hear about fracking, we hear about CSG, and we know that it has a bad impact, but for people like Shay who've been living it, it's almost unbelievable. When you live in the city, if you haven't been out to the gas fields, you almost can't fathom how bad and how hideous it is. And even when you get there, unless you've been there and you've seen the impacts, the bubbling water, the sick animals, the kids with rashes, you truly just don't know what's going on. So it seems particularly evil in a place like Queensland where so many people are so happy and comfortable that these atrocities are committed against our own people, all in the name of some kind of pretense of development. So I'm going to keep my talk a little short this evening because I know you've probably got a lot of questions, particularly for Shay and Amy. And mostly what I wanted to do is just remind us that the bill is important. It's really important. And around the world, we're getting to a point now where other countries have been for many years. So I'll talk really briefly about other countries that recognise the human right to a healthy environment and remind folks that some countries are going further than that and actually acknowledging that in today's huge human populations, massive extractivism industries, living daily with the impacts of climate change, the right of the environment to exist, thrive and evolve is rapidly becoming almost more important than a human right simply because without any of it, there's none of us. So the human right to a healthy environment, as of 2012, and that was actually the most recent reliable academic summary I could find, 177 nations of the 198 recognised in the UN already have a human right to a healthy environment. David Boyd's work points out that, 193 UN member nations, this can pop up in national constitutions, in actual environmental legislation, because remember Australia has environmental law, but within those laws there is no specific human right to a healthy environment. There are also court decisions, and many, many countries have ratified the types of international agreements that ensure that by merely acknowledging or ratifying an international agreement, that nation is bound to comply with human right to the environment. So as of 2012, which I know seems like 6 years ago, but I couldn't find the most recent summary other than David Boyd's excellent work, so it could be even less. We're in the company of the US, Canada, Japan, New Zealand. I have to check that, that can't be right. They're so enlightened. China, Afghanistan, Kuwait, Brunei, and many other countries. But as Rebel said in her opening remarks, there's really only about 15 nation states left in the world that do not have a human right to a healthy environment. So Boyd suggests that this rapid spread of the right is actually remarkable because it's only been happening in the last 40 years, and many of these new laws in nation states are much more recent than that. So just looking at that, we've got 108 nations have a constitutionally protected right to a healthy environment, and for anyone who's not a lawyer, the Constitution should be the highest law in the land, the foundational document for any jurisdiction. So 108 nations have a constitutionally protected right, and more than 100 have the right noted in their, or explicitly stated in their own environmental legislation. And more than 120 countries have signed legally binding human rights treaties. So across all of that legislation, what it means is it's not just the right to health, which can be defined in many different ways. A right to a healthy environment typically sets out things like clean air, clean water, fertile soil, the access to healthy food, peace and privacy, and often there's also rights around amenity, which means your life isn't miserable from over-excessive development. And there's nearly always recognition that kind of bridges human rights to culture, to human rights to the environment, which is around Indigenous peoples and other peoples' rights to traditional land, to cultural practices, etc. So I guess that, just a couple of slides, is to remind us that what we're asking for, what we would like to see included in the bill, if not now then soon, is not too much to ask. Many countries around the world are doing it. It doesn't guarantee perfection in the implementation of our protective laws, but it will mean that we've got, as Shay articulated so beautifully, we've got a little bit more capacity to protect ourselves once we're in that realm of conflict. Get our bigger gloves on when we have to battle it out. I also wanted to mention that for anyone who doesn't know about our work, the Australian Earth Laws Alliance, we're a small not-for-profit, very interested in how we shift from human-centred to earth-centred governance, particularly given climate change and everything that's happening around us reminds us whatever damage we do to the planet definitely affects us as a species, but we also, more than that, have no moral right to be stripping our planet of the beautiful biosphere that has evolved over so much time. And what's really interesting is that around the world, I think of it as particularly 21st century movement, you have countries, jurisdictions and grassroots bottom-up community work recognising the rights of nature. So remembering that a right to a healthy environment is a human right, something that I should have just by being a human being. But there's a whole body of work out there that's recognising the rights of nature to exist. And the rights of nature movement is a direct response to Western industrial style property law that says the living world is nothing more than property. When I talk to my Aboriginal colleagues and try to explain rights of nature, sometimes they say, I don't get it, why do you need it? And then when I explain how the property law and the entire white-collar legal system renders our living world as nothing more than property or background furniture, because it's all an object, then they understand that the rights of nature is a movement to reanimate the law, to remind us that it's not just us on this planet, and that all customary systems around the world, other than the sort of particularly post-industrial revolution legal systems, saw the living world as sacred, respectful, something that we interacted with, something that we lived in a sacred relationship with, whereas our legal system has evolved for many hundreds of years as seeing the rest of the non-human world as nothing much more than a playground for us to care for if we choose, or destroy, more likely. So since the, since about 2004, amazing people in the US have been using community-based, so they bring together community rights and nature's rights, and they assert the rights of local communities. It's called Earth Democracy, and they're trying to push back at the legal system by saying, not only do we local people, for many of the same reasons that Shay's outlined, battling up against really powerful companies that the law privileges, these people say not only do we as a community have a right to stop these developments and to actually live in a healthy way, but our natural world has a right to. And CELDEF, the work of the Community Environmental Legal Defence Fund, is really inspiring and has been exciting a lot of folks in Australia. But in terms of constitutional recognition, Ecuador remains the only country in the world to have a constitutional recognition of the rights of nature. In 2008, it brought it into the new constitution. But what's been really amazing are the sheer volume of changes that have been occurring around the world. So Bolivia has a national law which it brought in 2010, and then for quite some time there were a lot of activists pushing these laws. A lot of the local laws in the US were continuing to develop. There are several dozen of them, and several hundred communities advocating for their rights and the rights of nature. But what we saw from 2017 was this bubbling up of legal status change for a river, legal personhood laws being put in place for a forest, and although that was unique to New Zealand and its own cultural heritage and post-colonial compensation agreements under the Treaty Waitangi, we're now seeing other jurisdictions around the world looking at these developments and modifying them, whether it's through judicial activism or a combination of ordinary citizens arguing for the rights of their local ecosystems. We've seen India with several cases, and Colombia with 2 very successful cases recognising the legal rights of the communities on the river to protect themselves from unwanted mining activity, but also the legal rights of the river and all of its inhabitants. And what that means is recognising the living world not as an object, not as this background human activity, but as an equal player in the law, as being a subject of the law. It's a really interesting area. I can't say that that's going to bubble up in the Queensland space in the immediate present, but there are already people looking at rights of nature for the Great Barrier Reef, and we've drafted a few mock or model laws to show people what that looks like. And a lot of communities get excited about it because it actually shows them that they can advocate to be true local custodians of ecosystems in the living world. And in a lot of ways our work is interested in that. How do we embed in your average human a love of earth, care for country, and an earth-centred ethic? Whatever mechanisms we can use to push back at a legal system that is quite frankly outdated, we're really interested in those kinds of tools. So I guess I might just leave it there. I really just wanted to say that what we're interested in is shifting the world view from the one on the left to the one on the right, where we see all people and all living species and all life support systems as worthy of protection and care. And right now our legal system is not only leaving some of the nature out, it actually leaves a lot of people out. We've got an elitist legal system supported strongly by a system of government and industry collusion, and anyone who doesn't see that is not paying enough attention. So anything that brings human rights to the people and anything that brings more democracy to our system is definitely good for people and good for the planet. So, and I really do want to commend Amy and Shay for all the hard work you've done. We also brought earth rights, rights of nature, into the first PPT. So the same cases where Shay and other colleagues around the world were arguing for the human rights, it was the first time in 40 years that the PPT allowed in a rights of nature argument. And myself and colleagues from the UK and witnesses around the world brought those issues. So these issues are bubbling in many places. Queensland could well be the last one to get on the board, but I'm excited about our Human Rights Act, so I hope it will become an act very soon. So I'll hand over back to Rebel to MC us. Thank you.
Thank you so much, Michelle. If you haven't heard of the Australian Earth Laws Alliance, please look them up. They are a fantastic organisation across multiple sectors of our society: governance, the economy, religion, the arts. There are so many fantastic events that they will put on that really are, I think, providing a fantastic and really progressive and groundbreaking forum for change in our society. To get to the right-hand side of that slide, I just wanted to you set me up. Thank you very much.
You're right.
Michelle. Yeah. I just wanted to inform everyone what can we do to actually help get a human right to a healthy environment in Queensland reflected. So hopefully you're feeling as inspired as we are and about the need for this right to actually be reflected in our new bill. There is a parliamentary committee inquiry process that's occurring at the moment to reflect on the Human Rights Bill before Parliament. Sadly, submissions have closed for the public consultation part of that inquiry. You can still send them a submission to the committee secretary on the website. If you have any issues finding that, don't hesitate to get in contact with us. But it might not be accepted or put up on the submission inquiry process, but it doesn't hurt to get your opinion through to the committee still. It could be considered. You can still also write to the Attorney General, the Premier, the Deputy Premier, your local MP, and go and seek to meet with them to discuss why you think you deserve a right to a healthy environment. You can sign petitions. We've actually got one here today that I put out a bit too late after you've all arrived, but it's just on the chair as you go in. It's also online on EDO Queensland's website. There are many groups also working in this space, and not just in terms of getting a right to a healthy environment protected, but actually trying to support better laws in general and better support for communities out there, like Shay's community, who are really on the front line at the moment dealing with the lack of recognition of their rights to a healthy environment and to their own health. So Lock the Gate do amazing work in this capacity. The Western Downs Alliance, there are many organisations out there to stay in touch with. And just keep talking about it. I think the more we actually normalise this idea of having a right to a healthy environment, the more quickly we'll move to a society that does recognise it in our laws. But I have held it up enough. I will invite the speakers to
stand in our beautiful
stand
space.
in a general area here. We might just try to see if people's outside voices can be used to see if we don't need to have a microphone